This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about an unusual occurrence where an officer is caught aiding criminals for a cash payment, and a police officer who took bribes from an insurance fraudster found himself convicted of the crime. Demarkco Johnson, after his conviction, appealed his conviction and claimed the following errors. One, that the trial court abused its discretion in denying his request for a jury instruction on entrapment. Two, the trial court erred in failing to admonish and or instruct the witness to stop answering questions with a legal conclusion after the defense counsel had objected. And three, his convictions were against the manifest weight of evidence, and therefore his convictions were in violation of Ohio State Constitution and the Sixth and 14th Amendment to the United States Constitution. In State of Ohio v. Johnson, the Court of Appeals on October 24, 2024, resolved the issues on appeal. Defendants, including Johnson, were charged with 2 counts of conspiracy, 3 counts of bribery, 8 counts of forgery, 1 count of insurance fraud, 1 count of identity fraud, and 1 count of engaging in a pattern of corrupt activity. They engaged in a pattern of corrupt activity charge included a clause alleging that at least one of the incidents of corrupt activity was a felony in the 3rd degree or higher. At trial, George Michael Riley Sr. testified that he became a confidential informant for the Federal Bureau of Investigation, which was investigating corruption in the East Cleveland Police Department. Special Agent Sean Roth, an agent with the FBI working with the Cleveland Metropolitan Anti-Corruption Task Force, testified that the FBI executed a search warrant for one of Riley's properties. Harris's services included running Riley's name in police databases to check for warrants and blocking off city roads so Riley could move his demolition equipment throughout the city. 2 of Riley's trucks were stolen from his business in East Cleveland, and Riley told his contacts at the FBI, and FBI officials instructed him to file a police report with the East Cleveland Police, just as any other victim would do. Riley cooperated with the FBI, and after hearing the evidence, the jury found Johnson guilty of 2 counts of bribery as alleged in counts 5 and 10 of the indictment. The jury acquitted him on all the other charges. The court sentenced Johnson to 12 months in prison on both counts and ordered that the 2 prison terms be served concurrently. Johnson appealed the trial court's judgment. In the first assignment of error, Johnson argues the trial court erred in denying his request for a jury instruction on the defense of entrapment, but entrapment is a confession and avoidance defense, in which the defendant admits committing the acts charged, but claims that the criminal design arose with the state's agent. There is no entrapment when government officials merely afford opportunities or facilities for the commission of the offense to a criminal defendant who was predisposed to commit the offense. The video evidence presented to the jury showed Johnson handing Riley reports in exchange for money on multiple occasions. Johnson's conduct demonstrated a ready acquisition and acquiescence to the inducements offered by the government's confidential source and a willingness to become involved in criminal activity in exchange for money. The evidence showed that Johnson not only had expert knowledge as to how to create the police reports in a way that could go undetected, but he also had access to the blank police forms that made the concealment of the reports possible. The Court of Appeals found that evidence did not support an entrapment defense, and that cause of appeal was therefore rejected. In the second assignment of error, Johnson argued the trial court erred by refusing to instruct Roth to refrain from using the word bribe or bribery payment in response to questions that were not specifically related to bribe payments. Even if Roth had avoided the words bribe or bribery payment, the outcome of the trial would not have been any different. The overwhelming evidence established that Johnson helped create fake police reports in exchange for money. Johnson also argued that his convictions were against the manifest weight of the evidence, but the Court of Appeal noted that Johnson's convictions were not dependent on his knowledge of any insurance scheme or Harris's separate dealings with Riley. His convictions were based solely on his position as a police officer in the East Cleveland Police Department and his acceptance of cash in exchange for police reports. Video evidence showed Johnson accepting cash from Riley in exchange for the reports on at least 2 occasions. And despite Johnson's argument to the contrary, Johnson played along with Harris, introduced him to Riley as Neville's. The Court of Appeals ordered that a special mandate issue out of the court, directing the Common Pleas Court to carry this judgment into execution. The defendant's conviction having been affirmed, any bail pending appeal was terminated, and the case was remanded to the trial court for execution of the sentence. In my opinion, there can be no excuse for a police officer to sell information to an insurance criminal to ease the ability of the crime to succeed. Officer Johnson tried multiple arguments to set aside his convictions, even though the evidence against him was overwhelming. The Court of Appeals disposed of his argument quickly and intelligently. Fraud is a crime. Insurance fraud is a crime. Helping the criminal avoid prosecution is also a crime, and establishes that the officer had given up his honor for cash. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 4,900 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if either you or your friends view these videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.